Good morning. Happy Saturday. This is a video from James Freeman. He's playing a video from Good Citizen News. Good Citizen News goes to a courthouse in Georgia because his stated purpose is because that there are signs on the front doors saying that no recording is allowed, and he believes that those signs are unconstitutional, so he's going to see if they're going to arrest him for it, which is fine with me. I have no problem with that. Now, James Freeman believes, he states back here that it's important. Well, first of all, he says that most judges or most courthouses do prohibit recording. That is true. And he says that the way that they do it is with contempt. Maybe. I mean, that would depend on the courthouse. It depends on how the administration of the courthouse is structured. If, for example, there is a chief justice for that particular courthouse, like the chief justice of the Sacramento County Superior Court, something like that, the chief justice might, in his administerial role over the courts, make an order saying that these are the rules of how you can use the property. Now, that is perfectly in alignment with Adderley versus Florida. In Adderley versus Florida, if you will all remember, protesters wanted to protest on the grounds of a jail. And the sheriff who had custody, who had control over the jail, decided to trespass them all. And they said, wait, we're exercising our free speech. We have a First Amendment right to be here. And the U.S. Supreme Court said, well, no. The government has the right to maintain the property in its control to its lawfully intended purpose. The government can operate a jail as a jail. They don't have to let you go there and speak. And the only restrictions on the government restricting your speech on their properties is basically it has to be a legitimate government purpose. The restriction has to be rationally related to achieve that government purpose, and it has to be viewpoint neutral. So, for example, if a judge wanted to say, you can't carry signs into the courthouse, that would probably be fine because that's not viewpoint based. But if the judge says that you can carry signs that are praising the judge, but you cannot carry signs that are speaking negatively about the judge, then that would be a viewpoint discrimination, and that would be prohibited under the non-public forum basis scrutiny. Now, if you look at like a traditional public forum, that would be like streets, sidewalks. As U.S. v. Coquinda and U.S. v. Grace tells us, sidewalks, if they appear to be the traditional sidewalks that border a street, then it's more likely to be a traditional public forum. But if it's an interior sidewalk, like leading from a parking lot to the front door of a post office, that's less likely to be a traditional public forum and more likely to be a non-public forum, or maybe a designated or limited, who knows. But it's less likely to be a traditional public forum. If it was a traditional public forum, there has to be a compelling government interest. It has to be narrowly tailored to achieve the compelling government interest. It has to be the least restrictive alternative to achieve that government interest. And it has to be content and viewpoint neutral. So with that kind of understanding in mind, you can understand why a court could restrict filming in a courthouse under that kind of principle. Now, as James Freeman admits, he says, I understand that, courts don't want people swinging off chandeliers and causing disruptions. Well, just filming can itself cause a disruption. I understand the court's purpose behind that. I really like it when courts, I'm going to use an archaic term, televise or stream their proceedings. I think that gives the public a good insight as to what's going on. Like, for example, in the Kyle Rittenhouse case, if you only watch the news, you would not understand why the jury returned the verdict it did. But if you watch the entire proceeding and you watch the government's witnesses undermine the government's case, if you watch the government attorneys being inept in their in their cross-examinations and in their closing arguments and things like that, then you would understand why Kyle Rittenhouse was found to be not guilty. So I think it does. I think access to the courts by the general public is in itself a good thing. And I've seen more and more of it, especially with COVID. I believe Sacramento County is streaming. Are they streaming it on YouTube or are they streaming it on Zoom? I know you can watch on Zoom, but I think you could also watch on YouTube. I know several courts are in California are streaming their hearings, at least the ones that aren't involving like minors and things like that. So I think that's a good thing, and I think it should proceed down that path. Now, James says it's important that we record to expose all the corruption that goes on in court. And I've seen James Freeman's videos on court. I honestly have never seen any corruption that is certifiable corruption in a court. And in order for it to be corruption, it's not what the public thinks is corruption, although many judges are elected. And if you believe a judge is corrupt, you're more than welcome to vote against that judge, or if you're qualified to run against that judge for re-election, things like that. But there are some pretty strict standards placed on judges, pretty strict rules placed on judges, codes of judicial conduct, canons of judicial conduct, I think they're called, in addition to any rules of professional conduct for lawyers that judges are bound by. And as far as corruption going on in the courthouse, there are a lot of reasons why I don't believe that's a concern. First of all, I've never encountered a corrupt judge. I've encountered judges who I think have given bad rulings, erroneous rulings. I have prepared multiple appeals and writs seeking to change the opinions of judges who've made rulings, and that's the role of the attorneys. You got to remember, in every case, there's going to be, generally speaking, there's going to be two attorneys. There's going to be the petitioner / plaintiff / prosecutor, and there's also going to be an attorney for the respondent or defendant, whatever title you're putting on that other side. And there may even be like third and fourth attorneys, like attorneys for third parties, guardians ad litem. I mean, just all sorts of different attorneys that can be involved in this. And really the way that the courts are kept in check is that everything in a court that is important, if it's a oral arguments I think are the least important things, although it's what the public tends to gravitate towards. But the oral arguments are, if it's important, like for a criminal matter or whatever, you could always request, if it's a civil matter and they're not providing one, you get a court reporter, and they come in and they take everything down verbatim, and that's your record. And the things that are really important, like judges' orders and the actual arguments are really made on the pleadings. Like if you like Supreme Court cases and things like that, you might get a few nitpicky details clarified in the oral arguments, but the base, the brunt, the vast amount of the argument has already been done in the briefings, in the pleadings, before the court hears the oral arguments. And when you go to trial, then it's what you can prove at trial. I don't think there's any real corruption there. I mean, if a judge believes one side and doesn't believe another side, then that's up to the judge. So, James Freeman also says that judges are using contempt to punish anybody who they don't like. And I honestly, as an attorney, don't see the judges using contempt hardly at all. In fact, I think the judges are using contempt too little, because it is common practice. It's actually expected for plaintiffs and defendants and petitioners and respondents to lie. And I don't like that, because, I don't like the cavalier attitude the courts have towards it, because, well, we don't have a legal system, we have a justice system, but there's still a part of me, an idealistic part of me, that would love to have justice done. So I don't see what he's talking about in any of the prequel, but now we're going to get on to the part where I guess I really take exception. And without further ado, let's go.
Have a good day, sir. It's not a violation of rights. The official narrative by Deputy Price reads, on July 13th, 2021, a white male...
He's going to read through all of this. What I would like to point out is that James was kind enough to block out Good Citizen News' name, but not Clayton Moreland. I think that's a real jerk maneuver on Freeman's part. I understand that Freeman does not agree with Moreland, but I don't know. It just doesn't seem very, very sportsmanlike. Why can't we have differences of opinion about what is or isn't acceptable behavior? Like, I don't think Clayton Moreland had a reasonable expectation of privacy there, either under a Fourth Amendment standard, if he was being videotaped by the police or the court, which he was. I mean, it's a courthouse, so they're going to have cameras up. So he was getting videotaped, but I don't think he has a reasonable expectation of privacy from the Fourth Amendment perspective or from a invasion of privacy tort perspective, where he might sue Good Citizen News thinking that he's had his privacy violated, but he's certainly not going to get any damages, and he's going to have a hell of a time proving that he had a reasonable expectation of privacy there, considering that he was being videotaped by other cameras and probably by police body cameras and things like that. So it's a stupid argument, but I wouldn't have, afford the man some courtesy.
Who was later identified as Good Citizen News, came into the Dade County Court facility with his recording equipment in plain view. All entry doors are clearly marked that cameras are not allowed in the courthouse. Mr. Lewis was asked at least 3 different times to take his cameras out of the courthouse as they were not allowed. Mr. Lewis refused and continued recording, becoming verbally confrontational in his speech while continuing to record. He insisted on entering the courthouse, even claiming to be an attorney and a member of the press, but refused to show any card to identify himself as.
So what's interesting here is that James Freeman had talked about court orders at the beginning, and that is a natural way. A sheriff wouldn't make a court order to prevent people from protesting on jailhouse grounds, but he would make some sort of an administrative order. And, a court would make an order to prevent people from doing things as well. Now, in this particular court in Georgia, this might have been a municipal court or something along those lines. I'm not entirely sure, and I don't really care. But they may have some sort of an administrative order in place that is that it's tied into just using regular statutes to enforce it as the enforcement mechanism, not as a judge's order as the enforcement mechanism, and that's fine too.
Such. Mr. Lewis continued to record while officers were trying to get members of the public into the courthouse so they could conduct.
Now, as far as the refused to show any card to identify himself as a member of the press, as long as you're filming a matter that is relevant to the public interest, I think you are a member of the press. Now, there may be some administrative function where the court may allow credentialed members of the press into the courthouse to take video or photographs of particular trials of public interest. And that would be different. So I don't think that just to be a member of the press that you need some sort of a card. I know that was the rage a long time ago, people manufacturing their own press cards, but I don't think those are important or relevant. And I've never seen a case really turn on that. Legally, as long as you're filming something that is a matter of public importance, you're acting as a member of the press.
Conduct their business inside. Mr. Lewis went so far as to tell one female that she did not have to take her camera back out to her car because it was unconstitutional.
Yeah, that right there, telling someone that they don't have to actually comply with the instructions of the court or the policies of that particular governmental facility, that might be something that is against the law somehow. I don't know, but it might be.
He recorded a Mr. Clayton Moreland as well. Mr. Moreland asked that he not be recorded and that the video be deleted. Mr. Lewis told him that he was in a public place and refused to comply with the request.
Yeah, so he just because he's in a public place, I don't think is necessarily. There's a California case where a person got in an accident on the side of the road and they're terribly hurt, and someone wanted to film up close, and the police were pushing him back. And maybe I'm not remembering it really well, but I believe in that case the person had an expectation of privacy because they were being treated. I don't remember exactly, but it's a fact-based inquiry. I don't think that Clayton Moreland had a reasonable expectation to not be filmed in a courthouse where he was being filmed. I don't think that's reasonable.
Mr. Lewis was taken into custody for disorderly conduct under the Trenton City Ordinance 26.1 and willful obstruction of a law enforcement officer. So while most disorderly conduct...
All right. Section 26.1, disorderly conduct prohibited. It shall be unlawful for any person within the corporate limits of the city to disturb or endanger the public peace or decency by any disorderly conduct. Seems pretty vague.
Conduct statutes are completely unconstitutional. I figured we'd look it up and at least see what it says. The statute for this particular...
He said most disorderly conduct statutes are completely unconstitutional. Well, if they are, a court would have to say they are. And I would love to see where you believe that a Georgia court has held that this particular statute is unconstitutional.
City says it shall be unlawful for any person within the corporate limits of the city to disturb or endanger the public peace or decency by any disorderly conduct. The reason that these statutes are so often deemed so unconstitutional is because they're written like this, so incredibly vague that someone could be arrested under this statute anywhere, anytime, for doing or saying anything.
Yeah, I mean, that looks like it's pretty vague, doesn't it? Oh, whew, vague as vague can be. Yeah, I mean, it would really help the statute if there was something to identify what is and isn't disorderly conduct.
That somebody else doesn't like. While it's incredibly vague, it also gives a reference to the state statute, which basically...
Wait, it gives a reference to the state statute? I must have missed that. Let me see, reference to the state. I don't see a reference to the state statute here. But let's see what he.
Court facility in Dade County, Georgia.
That was a party fail right there. That was a party fail. Let me see where we're at. Party foul. There we go. Just trying to drag out my video.
It shall be unlawful for any person within the corporate limits of the city to disturb or endanger the public peace or decency by any disorderly conduct. The reason that these statutes are so often deemed so unconstitutional is because they're written like this, so incredibly vague that someone could be arrested under this statute anywhere, anytime, for doing or saying anything that somebody else doesn't like. While it's incredibly vague, it also gives a reference to the state statute, which basically states that...
So it gives a reference to 161139.
Disorderly conduct must include some type of violence. If you're...
Must include some type of violence. Boy, he just scrolled through that super quick. Didn't he? Wow, you just scrolled through that so quick, James. Well, let's look at 26.1 disorderly conduct. This is the Trenton, Georgia, 26.1 disorderly conduct. Yeah, that looks right. That looks like exactly what he quoted. And then it quotes state law reference 16-6-8 and 16-11-30 et sequitur. Oh, but wait, look at this. Same acts constitute. What is this? What is this? The following acts, among others, are hereby declared to be and constitute disorderly conduct. Use of obscene, abusive, or profane language. Making any threats of violence. It looks like they are giving you definitions of what constitutes disorderly conduct. That's freaking crazy. And did they reference 16-11-39? They did as an et sequitur, but they also reference this. So public indecency, there you go. And it has not been held to be unconstitutional. Nope, not unconstitutional. And then all of these, 1611-show riot, inciting to riot, affray. Affray is like where two people fight. Unlawful assembly, you got to have two or more people. Preventing or disrupting lawful meetings. I believe this one has been unconstitutional. Yep, so that one has been found to be unconstitutional. Preventing or disrupting, this one I don't think has been found to be unconstitutional, has not. Disorderly or disruptive conduct, blah, blah, blah. And let's see if the actual disorderly conduct, this one, let's see if it requires violence. If they do the following: if they act in a violent or tumultuous manner towards another person, where such person is placed in reasonable fear of their safety, that doesn't require violence, it just requires a reasonable fear of their safety, reasonable fear that of their property of getting damaged or destroyed, right? Fighting words, or using vulgar and obscene or obscene, vulgar, and profane language in the presence of or by telephone to a person under the age of 14, which threatens an immediate breach of the peace. This is like if you're tried to pick up young ladies, they can get you for that. So it doesn't require, like this one definitely doesn't require any threat of violence. Fighting words doesn't actually require violence. Anyway, so you're a little bit wrong there, James. Sorry about that, buddy. So yeah, I mean, good job there, James.
If you're a public official and someone recording you in your official capacity incites you to violence?
No. It doesn't have to incite them to violence. It could just be acting in a manner that disrupts the business. It could be just disruptive behavior, James. He's disrupting the court's operations, especially by telling people who are going into court that they could ignore the policies of that particular courthouse. Anyway, I think I've made my point. Thanks for watching. Have a great day.